I'm Malcolm Burrows, Principal of Dundas Lawyers. Dundas Lawyers is an award-winning corporate technology and intellectual property law firm that also passionately litigates in these areas of practice. In this video today, we'll discuss one of the most important court orders there is. These are called injunctions. This video explains the types of injunction available, the basis upon which they can be sought, and what conduct can be subject of an injunction. Injunctions generally are a court order which requires a person or an entity, of course, to do or not to do something. Prohibitory injunctions prevent an action from occurring, and mandatory injunctions force an action to be done. Prohibitory injunctions can prevent someone from doing any number of actions, from preventing the sale of a product involving trademark or patent infringement allegations, to preventing the publication or release of confidential information. Whereas mandatory injunctions can range from forcing performance under a contract to forcing a person to transfer their property, for example. Injunctions are typically sought on what's called an interlocutory basis. That means they are sought in as a step in the proceedings. In the case of Australian Broadcasting Corporation and O'Neill, confirmed that the applicant must demonstrate several things. These were that there is a serious question to be tried, that there is a matter of urgency, and that damages will not adequately repair the harm that has been done, and most importantly, that the balance of convenience favours the grant of an injunction. The last point means that the applicant must convince the court that their relief is more important than any harm done to the person being affected by the injunction. Interlocutory injunctions can be dealt with on what's called an ex parte basis, meaning that the other party or the respondent who's subject of the injunction is not notified. This often happens when an injunction is first of all needed urgently, but most importantly, where there's a risk of destruction of evidence. Rule 259 of the Uniform Civil Procedure Rules in Queensland allows ex parte orders to be made if the court is satisfied that there's an adequate reason. Almost any conduct can be restrained where circumstances permit. For example, in Curio and Beyond Productions Proprietary Limited, an employer was able to prevent an employee from breaching the restraint of trade clause. In Motorcycle Aftermarket Spares and Tamworth Cycle Tune, Dundas Lawyers was able to successfully obtain interlocutory and permanent orders preventing the respondent from breaching our client's copyright by selling of infringing products. In SAO Global Property and Johnson, employers prevented from releasing a database uploaded on a flash drive. These are generally urgent matters. As discussed, an injunction is a powerful remedy and one that should be considered where compensation is not likely to be a sufficient remedy. So if you are at risk of irreparable harm and looking for a proactive lawyer to advise on filing an injunction, please don't hesitate to contact me on 3221 0013 for a confidential and obligation-free discussion. Thanks for watching.